Okay, well, we're at the end of the day, and I have a paper about the role of copyright in developing creative industries in developing countries. So, we're all familiar with the narrative about how digital technologies have revolutionized creativity, empowered all sorts of forms of creating, distributing new works. And we should talk about that kind of creativity in the context. In the US, we think about pajama bloggers, we think about remix artists. But the effect of digital technologies and sort of the lowering of thresholds and entry costs to content creation has had equally profound effects abroad in the developing world. We're not talking so much about amateur creativity as emerging professional content industries that suddenly can kind of compete in the game of producing their own homegrown content. And that's a really exciting development. The question is, what are the implications for copyright? My sort of working starting point is the observation that copyright plays a more prominent role in these industries as they develop and grow and move towards more formal business structures. I've made this observation before, but I'm really interested in exploring the implications for policy. So what can we do about this? What should we be doing in terms of thinking about how to sort of help engage and sort of usher this along? And so just sort of an illustration of sort of how these shifts are happening. I want to give just an example. Going back to last November in China, where there was a copyright war that broke out. And this isn't a war fought by the RIA or the FPAA or any other Western content industry. Rather, it was something fought between Chinese companies, specifically Chinese web streaming services. So we have a number of them that are now in business, and they've started to exclusively license content. So they have sort of a mixture of content that's licensed and content that's not licensed, and the ones that have the licenses are suing the ones that don't have the licenses, who promptly countersue. Say, well, you infringed our stuff, but you're infringing but you're also infringing our stuff. And so there's been a series of these suits: November, December, May. Basically, all the big players are suing each other, which is great for copyright lawyers. But it's an interesting thing because until just a few years ago, really just very recently, the whole lifeblood of Chinese internet economy, or content hosting sites, was all based on pirated products. They were just competing to see who could amass the biggest collection of free content, and sort of trying to grow their market share that way. And now they're sort of shifting and suddenly turning, sort of opting into the copyright system, licensing content, and actually suing to enforce their rights. And this isn't just limited to the music content industry. Actually, it repeats a pattern that you saw in web video that Eric Priest, among others, has written about how two major YouTube kind of clone sites started licensing content and started suing each other and other sites. So it's very interesting just to see, kind of runs against our narrative of China as this den of copyright piracy. Not to say that piracy's gone away, but at least people that sort of tell the standard narrative that copyright and IP generally is a Western paradigm that was foisted upon unwilling victims like China and other developing countries, and it's contrary to Confucian traditions. Well, that may be true historically, but at the very least you can see a number of major players are now suddenly kind of opting into the system and actually using it quite vigorously, to the point that Chinese plaintiffs are some of the most active IP litigators in the world, and the vast majority of these cases are not are Chinese plaintiffs against Chinese defendants based on Chinese homegrown content. So this is sort of the key development, is that you have a lot of homegrown content. Obviously, people have a vested stake in enforcing rights in that content. That's perhaps somewhat obvious to say, but our standard narrative in IP, while in development, and you still hear this bandied around, for a long time, people talk about and sort of assumed as a given that content is primarily, or innovation is primarily a good produced in the global north exported to or pirated in the global south, that IP laws are all about trying to extract royalties and make Western corporations rich. Well, maybe that's still the case, and certainly the vast majority of IP wealth is concentrated in Western countries, but the balance is shifting quite rapidly, and also norms are shifting. So this kind of follows up on Ben's point about how do norms change, and I'm interested in sort of observing this, and also thinking about what we could do to kind of encourage it. It's not just China, obviously, I'm talking about. As I mentioned, these digital technologies have helped industries develop all around the world, and plenty of other very major content producers. So most obvious examples in film would be Bollywood and Hollywood, both of which are some of the biggest producers of movies in the world, making thousands of movies every year. And both of them had sort of shady pasts. Bollywood was run basically by gangsters and kind of played fast and loose with copyright. Hollywood was literally, for many, many years, for the first decade or so of its life, operated entirely by pirate networks who had just sort of discovered almost by accident that they could make more money instead of ripping off imported Nollywood or Bollywood or Hollywood movies. They could actually make their own movies and sell them for more money, basically using that same sort of pirate distribution network. So gradually, both of those industries were sort of legitimized and formalized, and there are a number of reasons why that happens. But well, I'll just say briefly, there's a number of theoretical reasons why. First of all, homegrown content is great, lots of positive externalities that cultural diversity theorists talk about. And it's obvious, as I said before, if you have homegrown produced content, you have more invested interest in copyright. The question is, why is copyright good for producing those industries? What does copyright do, and why is this trend towards formalization? Here again, I sort of have a number of sort of descriptive observations. I'm not sure I have a proper theory, but I'm trying to think this through, so I'm interested in people's perspectives. But what I can observe is that there's a lot of different sort of structural reasons why people in these industries may want to rely on copyright. It has to do with the fact that you can operate an informal business model for a certain point, but it's hard to scale that beyond that point as you develop bigger and bigger things. Simply geography. For example, in Hollywood, they can rely on sort of, we call it synthetic copyright, I guess, following the proposal, the previous paper. They essentially had hired goons who could enforce content exclusivity in the markets they wanted to sell their goods. That worked in the local area, didn't work so well when distributing all across Africa. So reasons like that, sort of other ancillary business models to appropriate revenue without directly controlling the copyright also don't scale as well. It's hard to plug into existing legal and financial structures, again, without sort of formalizing or working through the copyright system. If you want to distribute your movies to a foreign film festival, or get international finance or investors, you'd have here to certain formal structures. You'd produce documents, showing that you've cleared copyright and all the content. You have chain of title establishing ownership. There are a lot of these formal pressures, and also just sort of, I guess, more of an informal pressure that people don't want to do business with you. You're perceived to be playing fast and loose with sort of these global IP norms. This is, for example, a big reason in Eric Priest's account on why those web videos, Hoku and Yoku and what's the other one? Anyway, Tudo, why they turned to licensing is that they were getting pressure from Western advertisers who didn't want their luxury brands to be tainted by the perception of association with piracy. The other thing about copyright is it solves a lot of coordination problems. Again, a little example from Nollywood. At one point, they had a big problem with script piracy. Actors and other people would walk off in the middle of the set with a script and run off to somebody else who makes the same movie. So to solve that, they were releasing the movie scripts sort of one page at a time on a strict need-to-know, scene-by-scene basis. Doesn't exactly promote efficiency, in production. So copyright is sort of a, one way we can sort of build a little bit of baseline norms and trust, without having to go those other precautions. Okay, so this is sort of, I guess, some of my working observations about how this transition happens. What is it? What can we do in terms of policy? Well, I'm not really getting into the substance of what IP laws should be, because I think that's somewhat beside the point. It matters a lot for access to content and many other things, but really it's not so much about whether or not what the specific laws in the books are as how they're actually used and whether they get used and whether people know kind of have the expertise to work within them. And that's sort of norm development and many other things. It's also sort of technical, having private lawyers. So it's not, again, not so much about enforcing strong laws or weak laws on the books as getting the laws actually to be used. And to do that, it can't just be about enforcement. A lot of the tech transfer, technical assistance, and sort of training, rule of law programs that are operating really focus on training judges, training law enforcement to enforce copyright. Enforcement can't really stop piracy, maybe marginalize it a bit, if that. The best strategy actually is to co-opt the pirates. But better than that is, or in addition to that, rather than trying just to be focused on enforcement, you need to think more about using copyright as sort of a way to grow businesses, teaching skills other than enforcement, things I mentioned like chain of title, clearance, distribution. There are lots of technical skills that Western IP firms in the private sector have these expertises, know how to do these things, and it's that knowledge we need to think more about getting transferred rather than the public sector enforcement, criminalizing, that kind of stuff. So there's more I could say, but perhaps I should stop here, and I'd welcome your questions and input. Yeah.
I'm wondering, Sean, with kind of you think of Nollywood, maybe at some point it's when, on the one hand, initially they're producing, but they're worried about copyright, and then they learn there's something called idea expression, and they're actually free to take the ideas, but own their own expression. Is that, intuitively, that seems like a turning point for some of these, like when you go to the approaching copyright, whether it's a good or a bad, when you're a producer of content, it seems obvious, especially once, in that context at least, once you get to that point, right, where I don't have to worry about Hollywood, I'm taking all the ideas, right, and redoing them, and I get domestic protection now. Is that something you've observed, or familiarity?
I mean, there's certainly a certain amount of remakes happens in the Indian film industry in particular, but there's been some pattern of that in Hollywood. And that's another interesting question about where, I guess that does get to the substantive copyright norms of where should we draw that idea expression line. There's really a lot of, I think, value in doing that, sort of indigenizing content. And people debate about whether localization is just a Trojan horse for Western ideas, or whether it actually is, I don't know, you could do a lot of different things talking about product differentiation and rent dissipation. And, so I'd like to get there someday, but I'm thinking about it. I don't really have a good answer. Paul?
It seems to me like Nigeria and India behaving very, very rationally to increase copyright protection for their movie industries, strengthening your local industry, encouraging local creative people. Best of all, if you're raising the price of foreign cultural products, right? Because if you're granting broad copyright protection in general, the cost of U.S. work is finally going to go up. You're actually going to resist cultural imperialism by enforcing copyright law in movies and music really, really strongly. So that seems super rational. It looks less rational to me if these same countries were enforcing copyright in computer programs and textbooks just as strongly. So it'd be really interesting to see whether it's a monolithic move. We're just going to enforce copyright completely in all things. We just incorporated this norm and we're just going to push it as hard as we can, or whether it's a more selective enforcement where you enforce in the area where you're producing your own cultural goods, but you're not enforcing when you need the banking software for your banking industry.
Right, that's a very interesting question.
And I think you can get rates. I think that like U.S. Software Alliance or something keeps track of pirate rates in countries over time, and I know the RIA does. So you could probably get the data pretty easily to see music infringement in these countries and movie infringement in these countries and then software and see if
We need data on enforcement activity as well.
Well, in theory they're considering that, but yeah, then that's hard to figure out. I just don't.
Yeah, it's something that I've thought about actually before. There's a TRIPS issue about whether you can actually do that, but
No, you can.
well, it's not actually clear to me that how directly TRIPS would, how if you had a blatant policy maybe.
But you're right. You could direct enforcement in one.
Right.
Yeah.
You have a lot of discretion that way. And let's see, there was something else I was going to say. Actually, one observation, the first thing you said about raising prices of imports. You're spot on to say that to the extent that imported goods are pirated, they're undercutting the price of the zero price against anything you want to sell at. It has the opposite effect, though, interestingly, on legal sales and the pricing pattern of legal goods. So in Bollywood, in India, where they have locally, the legal price of Bollywood movies is low enough that Western companies also have to lower their DVD prices, where generally they price them very high in developing countries, higher certainly for the income level. They're only selling it to the 1%. Okay.
So 3 comments. The first one is about the North-South debate. And that is based on a very static view of North and South, right? So the examples we give you is basically emerging countries. And I don't think we will necessarily consider India, China, Brazil, all of those countries still much in the South, right? So that's one question. The second one is with respect to causality. I'm unsure whether you are suggesting that now for China, India, Nigeria, is a time for them to protect IP better, or whether if they start protecting IP better, they eventually will get to a stage that they can benefit from it, right? And I think even for myself, I'm still unsure with respect to China, whether things would actually be better or worse if they actually started protecting IP even earlier than now. But I know that now China will benefit from strong IP protection. And then the last one is about what type of expertise you can share with them. A good example would be copyright licensing. What we do here in Hollywood or in other places just would not work when the major rights holder is actually the Chinese government. Right? So if you're trying to bring those ideas over there or set up the collective licensing system within China, what if the major collective society is the Chinese government? And how are you going to deal with that?
Okay. I think I'm just not going to address your first question about whether they're north or south. We can talk about that offline. The point about the government and enforcement, whether enforcement is good. First of all, I don't think enforcement in any of these countries, there's been some government effort towards enforcement in Hollywood and Bollywood, but a lot of the trends they're talking about aren't so much like government initiatives to crack down, or they are, they've been pretty ineffectual. It's more that you have industries themselves that are sort of organizing around using copyright and sort of internalizing it. And some of it is directed not just on the markets in their home countries, but also they have diaspora audiences, and so some of the Bollywood companies are quite active in shutting down websites that cater to non-resident Indians in the US and Britain, or all around the world, but particularly big wealthy populations. So it isn't really about governments, it's more about tools. To your last point about the, can we just take a license that we use in the US and port it over and have it work? Well, of course, all licenses need to be adapted whenever you use them in a different context. But I think it's not specifically the licenses, it's just a set of sort of, a way of thinking about, I need to, for example, the idea of copyright clearance or assembling a chain of title, the principles of just the awareness that you need to do these things and document these things in order to be able to distribute your movie internationally or within copyrighted licensing systems. That's more important than the specific, here's the form you can use. people in China and India, you have smart lawyers there who can adapt things once they see the idea. So it's the idea, it's not the expression.
Let me give you an example. So in China, they always talk about this minor contract. Right? This is actually very shocking for those of us who have taken contract law. What do you mean by this minor contract? Right? And so that would be a good example that you have this idea and you try to bring the culture over there. It's a major mismatch.
I'll ask you about that.
Yeah, sure.
I know someone else wanted to ask a question about time. I have 1 minute and 30 seconds, so yeah.
Well, I thought you had a couple of key insights that I just wanted to make a suggestion about that. One being about technology, the other one being about the regulation of internal conflicts. I think it would be interesting to take that one step further and consider how technology affects more traditional industries. The one that I have some experience with is publishing in the context of media, where typically authors have been extremely disempowered. I mean, this is an understatement to say that, where they would have to pay to get their works published. There would be no contract, and there would be no expectation of any kind of payment from the publisher after publication. So, no such thing as a royalty that the publisher collects all the money. And I mean, this is how the system functions today in 2015. So, when you have something like self-publishing, access to technology, suddenly that power dynamic changes everything. And so this just might be one more step further for you to take. Because I sense a concern with social justice and what you're talking about, which is very exciting and underrepresented in case publishing generally. So that might be one further step that you could take.
Wow, thank you. That's a great example. I was aware of that. 3, 2, 1.